Hello, everyone, and a warm welcome. Good morning, good afternoon, or good evening, wherever you may are in the world. My name is Annette Magnusson, and I am the Secretary General here at the Arbitration Institute at the Stockholm Chamber of Commerce. And this hour ahead of us, we will be talking about a newly published book, The Investor-State Dispute Settlement System, Reform, Replace, or Status Quo. I'm very much personally looking forward to hearing from some of the authors and the following discussion here. As we all know, the investor-state dispute settlement system has been the focus of much debate for now a number of years. And I'm sure that most of you watching here today are quite aware or familiar with much of the content of this discussion. And this debate has also led, for example, the United Nations Commission of International Trade Law, UNCITRAL, to specifically address reform of the investor-state dispute settlement system. And this work is currently being carried out by UNCITRAL's Working Group 3 that has been working with this for some years now. Now, the interest from the Arbitration Institute here in Stockholm for the reform and in the sort of the reform agenda and the discussion stemming from this reform desire, this emanates from our role as a frequently used venue for investor-state disputes. And we have seen investor-state disputes here in Stockholm since the beginning of the 90s. And as of 31st of December last year, we have seen a total of 116 investor-state cases in Stockholm. Most of these cases have been decided under the SCC rules, but a number of them are also being decided under the UNCITRAL arbitration rules. And you may wonder then, what is the background to Stockholm Arbitration Institute having so many investor-state arbitrations under its auspices? And this is mostly because there are, as far as we know, 120 bilateral investment treaties that designate a role for either the SCC or Stockholm or Sweden in their investor-state dispute resolution provisions. And in addition, the SCC, together with ICSID and UNCITRAL arbitration rules, is one of 3 options for investor-state dispute resolution under the Energy Charter Treaty. So this is sort of the background as to why we see so many investor-state cases in Stockholm, and consequently why we here at the SCC have taken an active interest in being part of the conversation for the future of investor-state dispute resolution. I believe that as a neutral institution, it is our responsibility and our role to be part of this conversation. Just as we are a neutral ground between the parties in each individual dispute, where impartiality and independence is a key to everything that what we do, I do think that we need to sort of take on that role and fulfill that ambition also when it comes to discussing the important questions for the future for our field. Including how to develop investor-state dispute resolution for the future. So this is sort of the backdrop for our engagement in the discussion here today. This is the backdrop for me happily contributing a foreword to the book that you will hear more about here this afternoon. And the ambition here is really to foster an open and a transparent and a forward-looking discussion. And I personally strongly believe that with publications like the one we will be talking more about here today, we contribute to the forward-looking discussion. We contribute to having different views being heard, and in that we can together make 1 + 1 = 3. Because one thing I do know, it is important to hear the different angles, hear the different perspectives, listen to the practitioners, listen to the institutions, academia, and other stakeholders in the so-called system. And together then we can cross-fertilize smart ideas and in the end come up with hopefully something that is even better tomorrow than it was today. Today, you will meet the editors of the book, and you will also meet 3 of the authors from the book. And they will share their expertise in the conversation under the leadership of Patricia Shaughnessy. Patricia is a well-known person in international arbitration. She needs probably no introduction, but nevertheless, she is the founder of the International Commercial Arbitration program, master's program at the Stockholm University. And she is a former member of the SCC board, including as a vice chair. But first and foremost for me, she's a friend. So I'm very pleased to hand over the baton, so to speak, to Patricia to take leadership for the rest of this hour. Patricia, over to you.
Thank you very much, Annette. And I would say of all the things, being your friend is the most valuable. Annette has been a very important visionary in the international arbitration community, and she's taken a very strong leadership role and engaged in the investor-state dispute resolution issues that have been going on. She once said she had was leading the protests. She had taken to the streets, and we're looking forward to see how she will continue in that role in the future. Turning to today, I'm really excited to be able to join the editors and three of the authors of this exciting book. And the book is exciting because it's addressing some of the really key issues that are going on right now in the current work that's being done on the, quote, reform of investor-state dispute resolution. Now, I am going to very briefly introduce them by name. Their resumes all are quite long, and I encourage everyone to get a copy of the book, and then you can read their full bios in the contributors list. But we're going to start with Alan Anderson, who is the head of his own law firm, Alan Anderson Law Firm, based in Minneapolis, Minnesota. And he's also a door tenant at Littleton Chambers in London. And what's of particular relevance today among his many merits is that he has been very active in the UNCITRAL working groups 2 on arbitration and conciliation, and the working group 3, which is addressing the ISDS reform issues. And he's been doing so for a number of years. He has co-edited the book together with Ben Beaumont, who is a barrister at the Garden Court Chamber in London. And together they have brought together, I think it's 25 authors presenting 20 chapters of really important issues. And 3 of those authors, as I mentioned, are with us today. We have Brooke Govan, who is a senior legal researcher at the Columbia Center on Sustainable Investment at Columbia University. And we have Kinda Mohammadia, who is a legal advisor and a senior researcher at the Third World Network based in Geneva. And we have Victoria Shannon Sahani, who is a professor and assistant dean of faculty development at Arizona State University based in Phoenix. And with no further ado, I'm going to turn the virtual stage over to Alan and Ben to introduce the book.
Thank you, Patricia, and thank you, Annette, and welcome once again, everyone, to this afternoon, this morning, this evening's webinar. And I'm joined by my distinguished colleague, Ben Beaumont, and hopefully this will be a very informative and interesting discussion of a few of the critical issues that are being discussed with the investor-state dispute settlement system. Hopefully you can see the first page of a very short PowerPoint. I'm going to, Ben and I flipped a coin and I won, or lost, the toss rather, for a very brief introduction of the book and how it came about. I can get it to go. There we go. So how did the book come about? I think the important thing is the background, because as we have heard, ISDS, investor-state dispute settlement, is a very critical issue, particularly for developing and near-developed states. And if you get involved in ISDS arbitration, it is incredibly time-consuming and expensive, and can have very significant consequences, particularly on the state. Over the years, ISDS has become perceived as being inconsistent, lacking transparency, resulting in excessive damage awards and in not taking into account relevant stakeholders and the impact of decisions beyond the actual parties, particularly in the energy treaty and now climate change areas. As Annette mentioned, UNCITRAL Working Group 3 has been discussing reforms to the ISDS system since late 2017 when they began in Vienna. And I have been fortunate to be able to attend and participate in those sessions as a representative of FICA, the Forum for International Conciliation and Arbitration, which Ben Beaumont, my co-editor, founded a good many years ago, and he remains the chair. To say that those discussions have been oftentimes contentious would be an understatement, but they have been ongoing, and the areas of discussion have included things such as the creation of a multinational investment court or appellate review mechanism. The European Union has been very strenuously promoting a proposal in that regard. Reform of the arbitrator appointment process, which in part would encourage greater diversity in terms of gender of arbitrators and counsel, greater geographic dispersion of arbitrators and counsel, all things that we should be promoting and have been long overdue. Discussions have also included issues such as allowing states to assert counterclaims, the role of ISDS in promoting and protecting renewable energy, and of course, the impact of third-party funding, which is a significant factor nowadays. This book brings together 29 distinguished authors from around the world in 20 chapters, and it provides insights into how several geographic regions and economic cooperation areas have addressed the question of reform of the ISDS system, in particular the recent basically replacement of the North American Free Trade Agreement involving the United States, Canada, and Mexico by a new agreement, which, depending upon the country involved, who's discussing it, can be US-Can-Mex agreement, but it's new and it seeks to essentially do away with much of the ISDS system. It considers the EU's proposal and obviously the impact of the ACMEA decision and the subsequent policy statement that eliminates BITs. It tackles cutting-edge topics as liability of state-controlled entities, considers how investors may retain their right to pursue claims after termination of agreement, which of course is of great import given what the EU is doing. It discusses damages and the duty to mitigate, and of course, the use of mediation as an alternative to resolve ISDS disputes, as opposed to, in effect, boarding the international arbitration train and not getting off and being able to get off until it reaches the final destination. So those are some of the topics that this book addresses. If you are interested in buying the book, here's a link to where you can get it. For those of you who are in attendance or seeing this video, there is a discount code 25ISDS21. That's 25ISDS21, which can be used through 31 July for a 25% discount. So with that brief introduction about how the book came about and how it is important, I turn things back over to Patricia for the rest of the show.
Thank you very much, but you're not getting out so early because we're going to have you very involved in the discussions that I'm sure that we're going to generate. Let me make an announcement that I apologize for not making at the outset, and that is that we are recording this session. So everyone who is now signed up and part of this webinar, I assume that your continued participation is also equivalent to your consent to the recording. The recording will be made available through the SCC video channel, and hopefully we'll have lots of viewers taking part of the information and discussions that we're going to be having. So with that, I'm going to move right into having our three authors present the work in summary of what they've done, and then we'll be using this as a way to lead into a robust discussion. The first author that we're going to invite is going to be Brooke Guven, and the chapter that she wrote is on regulating third-party funding in investment state arbitration, a reform of the ICSID and UNCITRAL rules, and addressing holding the global institutions to their, oh, sorry, I'm mixing that up with Kinda, sorry. You're looking at the reform of the rules. And so let me give the floor to you, Brooke, and apologize for starting to bring in Kinda's topic already.
That's okay. Thank you, Patricia. I think it was also part of ours holding them to their development mandates, which I'll touch upon at the end. So thanks for involving me in this discussion, and to the SCC for hosting it. I'm going to share my screen and hopefully I can find the right PowerPoint on it. Let's see. Let's see. I'm not seeing my PowerPoint on here, so I'm just going to wing it and we will go from there. So like Patricia mentioned, the chapter I authored with Frank Garcia, Michael Garcia, and Carl Lockhart is entitled Regulating Third-Party Funding in Investor State Arbitration, the Reform of the ICSID and UNCITRAL Arbitration Rules. So looking at just the very beginning of that discussion, we're talking about regulating third-party funding, and there is quite a bit to unpack in those few words. So first of all, when we think about third-party funding, the definition of that term is actually the key issue when you're talking about regulation. So definitions can be very broad. They can encompass things like pro bono funding of claims, or contingency fees of law firms, or they can be much more narrow. So in the chapter we've authored, we are talking about the more narrow definition, and that is the commercial profit-driven investment into an ISDS claim. This kind of funding is scalable, it's profit-driven, and it is not subject to fiduciary or other ethical requirements, and therefore has impacts that other kinds of funding do not have. So that's talking about third-party funding. Now, what do we mean when we talk about regulation? Again, a sort of very broad term that is used by many, but not necessarily defined very specifically. So regulation, I'm grouping regulation into sort of three buckets. The first bucket is transparency. So that allows funding, it just makes it more transparent. But even with that bucket, there's a spectrum. So there is, for example, what ICSID has proposed, which is disclosing the existence of funding and the name and address of the funder. If you want to get a little more disclosure, you could add the beneficial owner of the funder. And even more would be the funding agreement, subject to sort of commercial confidentiality concerns. Then for all of these kinds of transparency issues, you have to ask to whom? To whom are we making this transparent? Just the tribunal and the parties or the general public? So that's sort of the first transparency bucket of regulation. Then there's what I'll call the sort of claimant and claim-based restrictions on funding. So those would say, you can have any kind of funding, funding would only be permitted in certain cases. Those cases may be situations where the claimant is impecunious, where the claimant is an SME, where a certain kind of claim, say a direct expropriation, is alleged. So those would be restricted to certain kinds of claims. And then the final bucket would be restrictions on the funder and the funding. So that would be sort of permitting funding other than, for example, funding on a non-recourse basis for a success fee that's dependent on the claim. So that commercial profit-driven investment. So regulation is also quite a spectrum, and we'll talk about what ICSID and UNCITRAL have been thinking in that regard. So when states are thinking about regulating third-party funding, we haven't really seen this discussion happening at UNCITRAL, but there are fundamental questions that need to be asked. Some of them are like, what is the benefit and cost of third-party funding? Is third-party funding something that states, as masters of their treaties, wish to permit? And if they wish to permit it, under what circumstances? And then what criteria might they be using to evaluate the desirability of funding? For example, does it advance the object and purpose of the treaty itself? And then how can rules be formulated to actually affect the desired outcome of the funding and its role in third-party or in ISDS claims? So when we think about what we know about funding, which would be the basis of answering those questions, we know that third-party funding is almost entirely unregulated in the ISDS context. It's almost entirely non-transparent. Empirical evidence is therefore quite difficult to collect and assess. And we know that there are approximately 40 plus known ISDS or funded cases, but that the actual number is likely many times, if not multiples, higher. So when we don't know all of this information, but there has been speculation, published papers, discussion amongst states and UNCITRAL that the impacts of third-party funding could be systemic. They could be actually impacting ISDS as a system of justice. Should we be thinking about a precautionary principle? Should we be thinking, rather than allowing third-party funding and restricting it in certain cases, should we be shifting that? Should we be thinking about prohibiting third-party funding, but allowing it where it advances other objectives? So flipping things on their face right now. And then, states need to think about how they're going to address the identified concerns as a next step, perhaps. So the book, or the chapter we have written, focuses on sort of 4 kinds of regulation. So we talk about incorporating it into new treaties, which is obviously the most simple, amending existing treaties to affect regulation, domestic legal reform, and then arbitration rule reform, which is really the focus of the paper, but the others are nonetheless also important. So thinking about how regulation can be achieved, I'm going to skip over new treaties because that simply involves negotiating new language and putting it into a new treaty. But amending existing treaties, there are both a treaty-based amendment, so parties to the treaty could go and amend it. We know that this is challenging. There are political barriers to states actually engaging in bilateral or multilateral amendments, and there's quite frankly, just limited time and capacity amongst relevant officials to engage in the amendments, among other challenges. We rarely see amendments, and there are reasons for this, which many others have talked about. But amendments treaty by treaty is probably a great challenge. Then there's a multilateral treaty option. So this is part of the discussion at UNCITRAL, taking one treaty, similar to BEPS or Mauritius Convention, where states could sign on and opt in to amend or to a regulation. There are some questions about this which have yet to be decided. So would there be one option? Would we only have sort of transparency, or would there be several? And then how would you affect that? Would there be a matching system like BEPS if one state opted for different kinds of regulation than another? So these are all the questions to be determined. Ultimately, the question is also whether it would be effective. Would enough states opt in, and would they opt in with all of their treaties? To be determined. So moving to domestic legal regulation. So funders, when they're thinking about relevant domestic laws, think about the law of the seat, where enforcement is sought, the claimant's jurisdiction, and jurisdiction in which the funder is located. So if any of those jurisdictions our funding is considered or is looked down upon or regulated, it may discourage funding of certain kinds of claims or funding as a more general matter. But this is obviously, domestic legal regulation is obviously not a viable approach to sort of a systemic and holistic regulation of third-party funding. So what the paper really, or the chapter really focuses on is arbitral rule reform. And here, specifically given this webinar, I would include all arbitral institutions. This paper really focuses on ICSID and UNCITRAL, given their development mandates. But I think, similar to the COVID statement that the SCC headed up, there is the possibility for collective action amongst arbitral institutions, which is an interesting angle to think about. But ICSID and UNCITRAL have been used in about over 90% of known ISDS disputes. And most treaties, which Annette commented on at the beginning, do consent to arbitrate under these rules, with exceptions, including the SCC rules under the Energy Charter Treaty and various other treaties. Both ICSID and UNCITRAL, which I think is the key point here, are currently involved in a reform process. So ICSID is currently involved in a rule reform process where third-party funding is part of that process. And UNCITRAL could ultimately recommend amendment to its rules to the Commission as part of the UNCITRAL ISDS reform process. So both regulation under both of these rules is a possibility at this time. ICSID and UNCITRAL have identified different problems about third-party funding. So ICSID has identified the problem with third-party funding to be the conflict of interest that may arise between arbitrators and funders. And as such, has proposed that the solution be the disclosure of the existence of funding and the name and address of the funder, only to the tribunal and the parties. UNCITRAL, on the other hand, has identified a much broader spectrum of concerns about third-party funding in ISDS. These include an increase in frivolous or unmeritorious claims, impacts on case management, so for example, decisions to settle, the targeting of certain profiles of respondent states, moral, ethical, and political issues involved in permitting an investment fund to benefit from injury to others, and I quote, the potential to derail the system from the very objective of providing justice. So UNCITRAL has identified myriad sort of options for reform, ranging from a full ban or restriction on funding through transparency, which is where ICSID is sitting, and may include others. So the paper sort of concludes with this idea that we have a lot of uncertain information about third-party funding that we're just beginning to understand. This information is held by the potentially regulated funders. So in this circumstance where we have potential costs that could be, really impacting systemically a system of justice, should we maybe not be employing a precautionary principle, restricting funding more than it is now, rather than, just sort of transparency? ICSID is a World Bank Group entity and has a mandate to support international cooperation and economic development. And UNCITRAL is a UN commission with all of the mandates of furthering international cooperation and respect for human rights. So I'll conclude there, but that is our paper, and I do hope everyone has a chance to read the book, because the other authors have also introduced great ideas, which I'm looking forward to hearing about now. Thank you.
Thank you, Brooke. Before we move to Victoria, which I think will give us some different perspectives on the related issues, let me ask just one large question that maybe you can give a quick answer to. And that is that, you talked about this idea of a lot of different ideas, but you talked about how it can be difficult to find a nationality for a funding. How do you assign where it would be regulated from based upon the funders or the funded parties and where the arbitration's taking place? And you also talked about this idea of perhaps allowing or permitting certain types of funding activities. And that leads into, how is it possible now that funding is so developed and so all over the place, is it possible to really create one harmonized approach, which is going to be used in different funding contexts and different jurisdictions under different rules, different treaties? Is the whole idea absolutely in fairy tale?
Thank you for that question. That was sort of the mental exercise we put ourselves through in trying to think through this chapter. And also in a submission we made to UNCITRAL, trying to even define third-party funding, because as you know, there's equity positions, there's debt positions. The third-party funding is itself, a broad spectrum of things. I think, where regulation, I think it is possible. We see the transnational finance effectively regulated. If you, and that's ultimately why we landed on the rules, because they apply to so many different arbitrations. And if you try to go through domestic jurisdictions, you get many, many different thoughts, opinions, views. If you go through, treaties, as we all know from the Mauritius Convention regulation through treaties, and in particular, reforming existing treaties is particularly challenging. So we did focus on the rules, but I think where there's a will, there's a way, and hopefully we've just tried to offer one solution that might be effective in at least capturing a very large percentage of ISDS claims that would be sort of a default through the arbitral rules.
But we'll see whether or not arbitral institutes want to have exactly the same approach to this controversial issue. I'd like to invite Victoria Shannon Sahini to introduce her topic, which is addressing the financial access to justice in investment treaty arbitration. And Victoria, I think, may be able to shed some light on, it's not all bad that there is funding. Victoria?
Thank you so much, Patricia. And thank you, Brooke, for your comments. And I look forward to hearing Kenda's remarks as well. Patricia is absolutely right. I'm here to provide a different view. I'm not to suggest that third-party funding does not have problems. It does. But I do think that there are some potential ways forward for the industry and for ISDS that might actually be helpful in addressing one of the big problems in ISDS, which is financial access to justice. And I'll talk a little bit, excuse me, about what I mean by access to justice and focusing on the emphasis on finances. There's a lot of other formulations for the term access to justice, and that's not what I'm addressing here, although I think those other aspects of it are very important. And they're addressed in other parts of the literature. I'm just going to focus on finance. So my chapter title, Addressing Financial Access to Justice and Investment Treaty Arbitration, is sort of a broad lens, but I do take third-party funding as sort of a narrow lens. Imagine looking through a telescope. I'm using third-party funding as a telescope or a microscope even to look at financial access to justice. It's just one piece of it. So I'll talk a little bit about the structural problem in ISDS that is sort of exacerbated by third-party funding. Then I'll talk about how third-party funding classically appears in ISDS and something called not-for-profit funding, which at the time I wrote this chapter was not as common, but it's actually becoming a lot more common. And then I'll provide a few proposals, just ideas for how to achieve better financial access to justice in ISDS. So generally, when we're thinking about the structural problems, starting off with that, we know that in classic ISDS, you have investors as claimants and you have states as respondents. And those roles are almost never reversed, meaning the state is almost never, except under a few treaties that provide for this, but in the vast majority of circumstances, they're almost never the claimant. The state is almost always the respondent and the investor is almost always the claimant. In addition to that, the states are not able, under most jurisdictional provisions of most treaties, to bring counterclaims. In addition, many of the older treaties, the classic treaties, don't even provide rights for states. They only provide rights for investors. So even if there was a jurisdictional mandate, the substantive rights that the states would try to enforce are actually not there in the treaty. So this rigidity is something that is a feature of ISDS. It's essentially how the system was created. And I'm sure there's a variety of political and historical reasons as to why the system was created that way. But the key is that that is the system that we have. Now, why does third-party funding exacerbate this problem? Well, third-party funders are paid in a very interesting way. So if we talk about classic third-party funding, moving to that portion of my presentation, funders typically fund claimants. And the reason they fund claimants is because claimants, if they win their case, they will receive some money. So if the claimant's going to receive money, then the claimant can then share some of that money with the funder, and that's how the funder can be paid. And this prevents the claimant from having to pay the funder directly out of their own pocket. If you know about attorney contingency fees or conditional fee arrangements or damages-based agreements in the legal profession, this is a similar type of arrangement, except of course the third-party funder is not representing the party as legal counsel. But from a financial perspective, it's that the party does not have to pay any money up front. You go through the case, and then if the party wins, they give money back to the funder, reimburse the cost, and then give the funder an uplift or success fee, just like you would with a contingent or conditional fee attorney or attorney working under a damages-based agreement. So as you know, in all of those contexts, the claimant is expecting to win and receive money. A respondent, when they win their case, what they're doing is they're avoiding paying money. And you can't really pay someone else from avoiding paying money. So that is one of the reasons why respondent side funding, just in general, not just in ISDS, but generally across all types of disputes, arbitration and litigation, respondent side funding is not very attractive to funders. So what that does is in investment arbitration, investor state dispute settlement, you have funders funding claimants and not really funding states. Now, there are a few notable examples of state side funding. So I'm not saying that it never exists, but the incentive structure is different and the financing structure is different. And for the vast majority of funders, their business model is such that they cannot sustain large amounts of respondent funding. So you might see some one-off cases, but you're not going to see a lot of it. But you're going to almost always see it on the claim side. And so this is the structural problem of ISDS. In commercial arbitration, just to provide a contrast, in commercial arbitration, where you have a contract, right, contract-based arbitration, you have one of the parties, A or B. A may be the claimant, B may be the respondent, but A can bring counterclaims. I'm sorry, B can bring counterclaims against A, or B could bring a separate arbitration, for example, against A. There's opportunities for both sides bilaterally to be the claimant. That means that there's equal access to third-party funding for both sides. In addition, either side can bring a counterclaim against one of the parties' claims. That would also be something that could be funded. So it's a little more balanced in commercial arbitration. It's the structure of ISDS that's creating the problem. Now, what's interesting is this structure is often referred to as one of the problems in ISDS more broadly as to why parties want to reform the system. So it's important that we think about this. Third-party funding is just highlighting a problem that already existed in the ISDS system. Okay, so the reason why this relates to access to justice is because in any system in which we are trying to assess whether access to justice is present, we have to assess the party that is not able to choose whether to be in the dispute. Meaning, the claimant files the case, so the claimant is willing to participate. The respondent is unwilling. The respondent is not the one filing, so they don't have a choice in the matter. They are in the case whether they like it or not. And if the respondent doesn't have access to justice, then you don't have access to justice in the system. So that's why the structural problem in ISDS, as highlighted by third-party funding, uncovers an access to justice problem within ISDS as well. Briefly, I'll just mention not-for-profit funding, and then I'll quickly give you a few possible solutions to this problem. Not-for-profit funding, Brooke mentioned for-profit funders, she emphasized those, but not-for-profit funders are also becoming more prevalent, and they can also create problems in the system, particularly with respect to conflicts of interest, as well as political dynamics. So a not-for-profit funder or ideological funder, you'll see a lot of different terms used. This is an entity or person who does not have a interest in the finances of the case. They're not trying to make money, or at least that's not their primary objective. Their primary objective is something substantive. So either they want a certain outcome, they want to create a precedent, or something else. They're trying to attack a certain industry, et cetera. And if they make profit, so be it, but that's not their primary goal. So an example, there's actually a good example on the defense side, and this one's industry specific. There is the Bloomberg Philanthropies Foundation and the Bill and Melinda Gates Foundation created an anti-tobacco trade litigation fund. And the idea for this fund was to help finance poor states who are being sued by tobacco companies like Philip Morris with respect to their packaging products or labeling laws on tobacco, requiring certain labeling. And as you may know, Philip Morris had went around the world suing countries regarding their plain packaging laws. And so this fund was created to help those countries defend themselves. Now, this fund is not trying to seek profit. It's just trying to bring about a certain result and fight against a certain industry. So that's just one example. These funders are going to grow in scale. And also, you also have another type that might come up more often too, which is crowdfunding. So we already have websites like Kickstarter and et cetera, where you can crowdfund companies or someone who has a new idea for a product. But I think there's going to be more, and there's a little bit already, crowdfunding of international arbitration and investment arbitration as well. And then finally, I will mention a few quick proposals. And again, these are just sort of a laundry list. There's more detail in the chapter. And also others in the book and in other sources have discussed these types of solutions more extensively. So I won't be able to address them deeply, but I just wanted to list a few for them for you. One is to make respondents more attractive to dispute financiers. So one way to do this would be reputational benefits. If a funder is willing to fund respondents, maybe that might be a boost to their reputation. Maybe they might, the funder might say, I'm trying to increase access to justice, so I'm going to fund respondents. And that might be something that benefits their reputation and therefore it helps them to get more cases in which they do make money. So that might be one potential solution to incentivize them. Another solution possibly would be public funding. So there are a few governments around the world that have public funding for class actions. You could have a public fund for states. You could have a mechanism like what exists in the WTO, where there is some financing available, and actually third-party funders are trying to create a WTO dispute settlement funding market, not opining as to whether that's good or bad, just saying that that exists. But some idea of some sort of public option for funding that then takes it out of the for-profit financial realm. A third would be asking funders to modify their criteria as to what cases are worthy of funding. So for example, if increasing access to justice is a worthy goal, if that becomes part of the financier's criteria, then maybe they'll fund more respondent states. A fourth potential solution is to renegotiate investment treaties. Brooke mentioned this as well. This is something that is sort of the dream for a lot of different areas of reform, but in terms of reality, this is very difficult to achieve for reasons that are more complex than we can discuss here. And then the fifth solution is leave the treaties as they are and instead change the jurisdictional language in the arbitration rules. So if the parties then accept those rules and they can say, okay, now we'll allow counterclaims under these particular rules. There's a lot of issues with respect to that as well. And one of them being, you can't have rules that conflict with the treaties. So if some treaties say yes and some treaties say no, then your rules have to be what's called trans-substantive, which means that they don't, they're substance neutral. So there's a little problem with that one as well. And then the sixth solution, which is addressed by others much more eloquently than I, is to create an investment court. So sort of bypass the ISDS system altogether and have judges instead of arbitrators. If you go into that type of system, then you could just prohibit third-party funding. You wouldn't even, and the judges would have power if the funder tried to get involved in the case. So those are just a few options out there. None of these are perfect. And I look forward to further discussion about your thoughts on this very controversial issue. Thank you.
Thank you very much, Victoria. We're going to come back and hopefully have a discussion with all three of you. But one quick question, let me ask you. If we go over to this idea of an investment court, how does that actually, apart from the costs which the state will have in defending itself in the court, are not likely to be substantially different than the costs that they would have defending themselves in arbitration. And is the only win on the structural equilibrium banning third-party funding?
Sure, I'm sorry.
Go ahead.
Oh, I was going to say, sure, that's a really great question, Patricia. I think, number one, a lot of the proposals regarding creating an investment court have not fully fleshed out what all the parameters would be. But let's say we're living in a perfect world, which we are not. But let's just say we were, and we could create the best structure possible for the investment court. And let's say that one of the parameters was to either prohibit third-party funding or severely limit it to certain types of cases. The advantage of judges over arbitrators is that judges have what we call police power. So judges can subpoena, judges can enforce injunctions. They have power over parties in a way that arbitrators do not. That's one of the reasons why we have to go to court to enforce arbitral awards, right? Arbitrators cannot enforce the awards they make, whereas in many ways judges can. So it sort of creates more of a authority in the system, because right now the funders are able to argue, well, we didn't sign the arbitration agreement, so the arbitrator can't tell me what to do. The judge has power over everyone in the courtroom, regardless of whether they're a party in the case. And I think that would be something that actually would give a lot more control to the situation over the third-party funding issue.
Well, it would certainly give more control for the state over everything.
That's true.
Filipinos appointed as judges, and I guess the state would have to finance this court system, which may not be cheap. But I'm now going to, we can save those questions for later. I'm now going to invite Kinda Mohammadea to introduce her chapter, which is on alternatives to the arbitration reform. And perhaps she'll let us know whether or not we're headed towards courts or if we're still going to be in the arbitration sphere. Kinda?
Well, thanks a lot for the invitation and for organizing this event. Yeah, as mentioned by Patricia, my chapter has dealt with the kind of a question that has been underlying the deliberations of Working Group 3, which is whether the reform is only focusing on making arbitration work better, or whether it is encompassing as well consideration of alternatives to arbitration as means to settle investment disputes. And to be frank, at the beginning of the deliberations of Working Group 3, this question was more prominent. But like as the process evolved, we have seen more recently that the way the agenda is organized and the deliberations are evolving, it has taken a much narrower approach to reform. But when I discussed in the chapter the notion of alternatives, I dealt with mediation, the role of domestic courts, and the role of state-to-state led mechanisms. And I argued that like addressing and integrating these alternatives in the envisioning of the investment dispute settlement regime would contribute towards enhancing the relevance and the legitimacy of the outcomes from Working Group 3. And this for several reasons, including one, that the mandate originally when it was crafted, the member states behind the mandate have thought more broadly than arbitration. So in the reports of the sessions where they have discussed this issue, they have spoken explicitly of the importance of discussing the role and considering the role of domestic courts, state-to-state dispute settlement mechanisms, and other means, including mediation and others. In addition to that, the recent practice of states, both developed and developing countries, show that several have chosen ways away or moving away from arbitration in their treaties. So they either don't have arbitration-based ISDS altogether in the treaty, or they limit the reliance. So for example, they would require exhaustion of local judicial remedies, or they will narrow the subject matter scope of what could be arbitrable, etc. So thus the multilateral solutions should reflect the trajectories that countries are adopting in their different treaty practices. And third point is that the history of international investment agreements has not originally or all the time incorporated arbitration-based ISDS, and the history of ISDS itself reflects the recognition that international arbitration was a complement, is to be a complement to other means of dispute settlement, particularly domestic legal processes, and not a total replacement as a situation that we are more or less witnessing today. And to that effect, you can look at the Exit Convention, for example, which explicitly says that investment disputes would usually be subject to national legal processes, but international methods of settlement may be appropriate in certain cases. So that was in the thinking and the intention of the drafters of the Exit Convention as well. So I will not touch on all the three issues that I discussed in the chapter, but I will pick up on mediation as a potential alternative. And to discuss a little bit the current situation, but also issues to consider in the way forward. One, we know that from the discussions at UNCITRAL Working Group 3 and beyond that, mediation is being casted as a viable alternative to arbitration, especially given its less adversarial nature. And that will help with the kind of keeping investment or the retaining investment in host states, given the less adversarial kind of conflictual relations which would emerge from arbitration. Also, mediation is addressed in multiple rules and institutions which are set to administer mediation, including the Stockholm Chambers of Commerce. So kind of like the infrastructure is there. And there's increasing number of references to these methods in treaties, both as mediation as a precondition to arbitration or as a standalone mechanism for resolving dispute. So we have kind of a scene which is kind of mature or ready to see mediation evolve as a more prominent means to settle investment disputes. But generally, we still don't see a big number. There's very limited number of mediations happening. Despite saying that, I would give a disclaimer that we do not know as much as we should know, because the picture is not complete, given that much of what happens through mediation remains confidential and there is no access to the public to this information to track. But we have seen a milestone, I think, in the for mediation and for its future, with the completion and the entrance into force of the United Nations Convention on the settlement agreements resulting from mediation, which focuses on the enforcement or the cross-border enforcement of settlements resulting from mediation. And this convention has increased and would definitely increase in the future the relevance of mediation, particularly to investors. So this convention resulted from negotiations at UNCITRAL in Working Group 2, and it provides a set of multilateral standards and rules to facilitate the cross-border enforcement of these settlements in a way that in a very similar way to the way the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards works in case of or in relation to awards resulting from international arbitration. So it really, in a way, and we know the New York Convention is a cornerstone in the arbitration-based ISDS regime. Like if investors do not have this kind of guarantee of enforcement, or at least like this level of facility at the enforcement facilitation at the enforcement level, the whole regime will not be as, I guess, as attractive as it looks today. So basically these rules say that if a country joins the Singapore Convention, it makes it easier for investors to enforce settlements against it in other jurisdictions party to the Singapore Convention. So for sure, the strength of the convention is by the number of the parties to the convention. So unlike the New York Convention, which have a high number of parties, the Singapore Convention doesn't at this stage. I think they are 6. But like this I'm just mentioning this to say that the viability of mediation as an alternative has been enhanced by the Singapore Convention. But the main point I want to come to is that when we are considering mediation as a potential alternative, it is very important to be cautious in the way we approach this so that we don't end up replicating a lot of the problems or similar problems to the current ones being faced in the arbitration-based system. And it is important as well to be very deliberate about designing approaches to mediation that take into consideration the alignment with the Sustainable Development Objectives. So here I would say a few issues are very important. One,
apologies for interrupting you, but we've only got about 5 minutes left. So if you could come to your conclusion, we'll continue the discussion, and we'll maybe perhaps go an extra 5 minutes over our time.
Sure, I will just mention then these points and come to conclusion. So for me, the issues that would be important are dealing with confidentiality, which is considered kind of cornerstone for mediation. But I would see that kind of relying on a confidentiality-based system would replicate the problems we faced since a long time with arbitration, which is the lack of information, and what lack of information and secrecy means to the impact on the states and the impact on the regulatory space. The second thing is the importance of realizing that the role of mediation will be different depending on the nature of the disputed issues. So a dispute related to public interest issues like environmental regulations or an human rights involving issue should be dealt with very differently from an uncompensated expropriation case, for example. So this is why confidentiality in these situations would not serve as the objective of justice. And the last thing I would say that the consideration of mediation should take into consideration as well the differences or the imbalances in between the economic power of investors and host states that is like very clear in certain cases, and the potential implications on the regulatory space, particularly the chilling effect. So
I think we need to go. We only have a couple minutes left. I'm sorry to cut you off. But let's, there have been a couple of questions, including one about mediation. Let me invite Alan, if you would like to, did you see the question in the Q&A, whether or not this book is going to serve as authority for, for some of these pressing issues?
Thanks, Patricia. Yes, just to restate the question that we have, the question is that the individual is curious to find out what position the book has taken regarding a multinational investment court, and whether it supports it or otherwise with ISDS, and it goes on to say, with ISDS being a lex specialis, could we finally quote authority on how to settle the term interference in arbitral awards? And that's obviously a very good and critical question. The book does not take a position per se. We have more than one contributor who addresses the issues surrounding both a multinational investment court or a appellate review mechanism, and the EU's proposal in that regard. I think, as Kinda hinted or suggested early on, there was a lot of discussion early in the UNCITRAL Working Group 3 sessions about a multilateral or multinational investment court. I think that everyone recognizes the difficulties with trying to create such a court, in that there is no uniform law relating to bilateral investment treaties or international investment agreements, and that's one of the critical issues. There's all differences in terms of what the provisions are, and all of these proposals go to trying to obtain a greater degree of consistency that's perceived to be lacking in ISDS decisions. Whether we'll get there, I don't know. I think it's more likely thus far that what may result is, at least for the EU, an appellate court to hear those disputes. I think it's unlikely that we're going to get to a multinational investment court simply because of the difficulties and the fact that even if one was created, it's going to have very little impact on all of the disputes that have gone on in the past or the treaties that exist, because you're only at best going to be able to incorporate that, if you will, procedure into future disputes and future treaties. So I hope that answers the question. If not, just give a response in the Q&A. Thank you.
Good, and let me invite Brooke and Victoria and Kinda we'll go an extra 5-6 minutes here over time so we can have a bit of a discussion on your interesting topics. And I wonder, it seems like you're all addressing the issues about the imbalance in the relationships between the investors and the states, and trying to find ways to achieve that. Perhaps Kinda's presentation on mediation, in the mediation context, perhaps there is greater balance. Are we seeing funders, Victoria, that are funding even at the mediation stage, or are funders more interested in getting on with the dispute?
Yes, so I have seen there is funding of mediation. In fact, there's a Elaine Greenberg who's a professor in New York. She writes about funding of mediation. When I've seen it, it's only been when there's a staged dispute resolution clause. So if the dispute resolution clause ends with something adjudicative like litigation or arbitration, but it starts with something like mediation or conciliation, then the funder will fund all the stages. But I have heard that there is funding of pure mediation, and that the funder would then be paid from part of the settled amount.
Mm-hmm. And Brooke, how do you see that this would come into trying to achieve the development goals? It seems that's the aim that you're focused on.
Yeah, that is the objective I'm focused on, mostly because it's in the preamble and object and purpose of most of the treaties as well. So I think mediation is an interesting opportunity. I think Kinda raised some really good points about it, in that we need to be careful not to repeat some of the concerns that have plagued ISDS and that have landed over 100 states thinking that there are problems with ISDS that merit multilateral reform, third-party funding being one of them. So yeah, I do agree mediation is a great option to consider.
And Kinda, do you think, how do you perceive the future of the Singapore Convention? It's going to take a while to get up to the New York Convention with 169 members. So it's still, do you see that perhaps it might be more applicable to underlying commercial disputes that may trigger at an early, may trigger an investment dispute, that you could mediate these things before they get crystallized into a contentious dispute? Or do you see that as a post-dispute mechanism?
Well, the thing is, yeah, for sure, the picture of, or the scene pertaining to the Singapore Convention is very different than the New York Convention. But when I looked at the idea underlying the convention, I saw that it's trying to kind of pitch a potential future for mediation that is similar to arbitration. And in terms of kind of giving this guarantee of enforcement. And the thing is, participation of states is for sure a reflection of the intent of the state, but also is the result of a lot of political pressure sometimes, or trajectories of other states. Or as well, like participation in the New York Convention is considered one of the indicators pertaining to the readiness of the state, in the international investment governance scene. So if the Singapore Convention goes that way and becomes prominent, I am giving more of a cautious kind of remark. Mediation is important as other alternatives like domestic courts or state to state, but we can go either way. We can go a way which tries to give the investor another avenue, which is not transparent, where imbalance of powers could work for the service of certain investors, and then we kind of create another challenging system like the one we are facing today and trying to correct. or we can go the right way. And in order to go in a better way, we really need to face the big questions. Transparency is the starting point. If you're going to hinge the whole mediation alternative on confidentiality as its cornerstone, then this is a no-starter. So if we are able to deal with that, then we are able as well to bring more issues into consideration, like the balance of the power between the two parties to the dispute, etc. So I'm just saying that it is important to consider, but it needs a much more in-depth conversation and frank conversation regarding some tough topics. And this is not currently happening, unfortunately.
And Victoria, if you look from your prism of trying to find the access to justice, and if you had the magic wand, which would you, if you're going to venture, which do you think would put the state's access to justice on more equal footing?
Well, this is one of the challenges. As I mentioned during my presentation, there's a lot of aspects to access to justice besides just financial. And so we haven't in this panel been able to explore all the other aspects. There are some substantive access to justice issues. So for example, many of the treaties don't even have any rights for states to vindicate. There are some procedural access to justice issues. For example, the question of whether host state courts, when there's exhaustion of local remedies required, are host state courts really a fair place for an investor to have to go? You know, probably yes, but maybe in some states not so much. There's also access to justice issues with respect to arbitrator selection. So some would say if an arbitral panel is not diverse enough, or if there aren't possible participants. So for example, in ICSID arbitration, you have to choose from their list. If there aren't individuals on that list that accurately or that represent the views of a variety of different genders, races, nationalities, cultures, geographic locations, etc., ages, then a party might argue that they're not getting justice in the system because their tribunal is not appropriately formed. So there's a lot of ways we can talk about access to justice. And so, yeah, if I can wave a magic wand and ISDS was just to every participant all the time, you know, the reality is it would probably be very different for every participant because every participant has different goals as to what they want to see achieved that would represent justice for them.
Great, thank you. And in their departing minutes here, let me ask you, Brooke, do you think the efforts to try to create a base, a pool of information to help states to have, you know, access to different information that will help them, access to funding, do you think that that would counterbalance the TPF for the investors?
I think there's two elements to that question. I think Victoria addressed quite well the sort of imbalance that prevents states in the current system from achieving, you know, the same kind of funding that claimants are able to obtain. So that's one part. I think the information is absolutely key though, because regulating anything absent information is nearly impossible. You know, you have to have both agreed on the objective of what you're trying to achieve and what you're trying to regulate, but then also information. And so absent information, it's really, really challenging to understand what is going on and what you need to regulate. So while I applaud ICSID for, you know, trying to introduce more information through their rules, I'm not sure it's enough, especially if it's only going to the tribunal and not to the general public, so that people can study and understand what is actually happening in the context of third-party funding to better formulate rules. You know, it may be that states do wish to allow funding in certain circumstances, but without information, it's really hard to say. So I think that's key.
Information is key often, especially in our information age. In our remaining 1.5 minutes, I'm going to turn over to Ellen again. And I'm going to briefly answer the pending question on mediation. And I would like to already thank all of you for what would be a discussion we could have for the rest of the morning, afternoon, or evening. Alan?
Thanks. The remaining pending question relates to mediation being a conditioned precedent to arbitration, and whether it can be broadly scoped. And I think one of the critical aspects of mediation is it is very flexible, and you can the parties, once they get to mediation, can discuss any issues that they want, because the objective in mediation is to bring the parties together to an agreement and not to force any resolution on them. So that's one of the benefits of mediation, whereby you can go in and get a result or get an agreement that addresses far more than what would necessarily be addressed in an actual dispute in arbitration or in court. And so that does provide the flexibility, or the opportunity at least, for the parties to sit down and discuss not just the issues that might otherwise be determined in litigation or in arbitration, but that would are out there and may arise in the future. So hopefully that answers that.
Great, and now we're 10 minutes over time, and so we really need to close down our webinar. But hopefully we have opened up a lot of ideas and thoughts and discussions, and I encourage everyone to get a hold of the book and explore the issues there. Thank you so much to Annette and to her team, to Alan, to Ben, to Victoria, to Kinda, and to Brooke. It's really been a privilege to explore these very hot topics. And I look forward to reading more from what you will all be contributing in the future. Thank you.
Thanks, everyone.